Today marks a very auspicious day in the life of our court. To tell you more of this, I invite Mr. Justice Saunders, President of the Caribbean Court of Justice, to address you. President Saunders.
Thank you very much, Madam Deputy Registrar, and a pleasant morning to everyone. Indeed, today is a red letter day for the Caribbean Court of Justice. It's a cause for celebration. For the first time in the 19-year-plus history of the court, we have two women who are part of the bench. Women naturally bring to any decision-making, adjudicative process that is established all the unique qualities that are inherent in being a woman, and perspectives and insights which do not come instinctively to men. This naturally makes for more rounded and, I dare say, better decision-making. And so it is with great pride that we welcome Justice Chantal Ononewu to the Caribbean Court of Justice and to this bench today. Justice Ononewu emerged as the successful candidate in a recruitment process that was competitive, transparent, and scrupulously premised on merit. Of course, that process was triggered as a result of the vacancy that was created by the untimely death of the late Mr. Justice Jacob Witt. But out of that rigorous process, she emerged as the successful candidate. She has considerable experience as a litigator, and we are so very happy to welcome you, Justice Ononewu, to the bench of the CCJ. And I'm sure, I know that you would make a tremendous contribution to Caribbean jurisprudence. Thank you.
Thank you, President Saunders. I take real pleasure in welcoming warmly Madam Justice Chantal Ononewu to the bench of the Caribbean Court of Justice. I believe it is true to say that Justice Ononewu is the youngest judge ever to be appointed to this court, a fact that is significant to the future stability and continuity of the court. She evidently brings diversity and a greater gender balance to the bench. I have known the judge for over 3 decades, significantly over 3 decades, and can attest that the qualities, competencies, and experience evident in her resume are entirely accurate and deserving. The judge is an outstanding product of regional legal education. A jurist of meticulous scholarship, particularly in international law, including international trade law, she will assist in further developing the jurisprudence of the court in the original jurisdiction. She will undoubtedly also make an outstanding contribution to the appellate jurisprudence and as well to the outreach activities of the court. So again, a warm welcome to you, Justice Ononewu, and I look forward to collaborating with you on the work of the court. My very best wishes. Thank you.
Honorable President and colleagues, Council, the staff of the CCJ, good morning, everyone. It gives me great pleasure to welcome my sister, the Honorable Madam Justice Chantal Ononewu, to the Caribbean Court of Justice. Justice Ononewu brings to the court a wealth of experience, a profound commitment to justice, equality, and the rule of law, and an unwavering sense of duty to the peoples of the region. Importantly, She comes from a rich tradition of devotion to family, service to her beloved country of Jamaica, her adopted country of Barbados, and to the peoples of the Caribbean community. In addition to her stellar legal and professional achievements, Justice Anonymou is highly regarded for her courtesy and consideration, two of the core values of the CCJ. The CCJ's strategic plan encourages us all to demonstrate care and respect for all, and to exhibit politeness, due regard, and empathy to all. I wish to add that our new judge is also held in high esteem by her former colleagues for her humility and kindness, indeed rare qualities today. As her elder sister, I welcome Justice Anonymou with open arms. I trust that she will remember that we stand on the shoulders of our dearly departed sister, Justice Desiree Bernard, the only woman to be appointed to the inaugural bench of the CCJ. Justice Bernard has made a lasting and invaluable contribution to the development of Caribbean jurisprudence. Throughout her many years, both as an attorney and as a judge, Justice Bernard lent her voice to the struggles of the vulnerable and the marginalized. In closing, I wish to place this little and interesting anecdote on the court's record, please, President. We are told that when Justice Bernard received her many honors, accolades, and awards, she would always remark, "There are many more deserving, but none more grateful." May we always learn from Justice Bernard. Welcome, the Honorable Madam Justice Anonymou. Thank you, President.
Mr. President, thank you very much. Good morning. Madam Justice Anonymou, welcome to the Caribbean Court of Justice. I do not propose to retrace the track which my colleagues have beaten. I merely wish to say that I endorse all the sentiments from the President, Mr. Justice Anderson, and Madam Justice Rasmussen. I embrace all of these sentiments, and I wish you a most outstanding tenure at the CCJ. As Justice Anderson pointed out, yours will be a long tenure, and I think it will contribute enormously to the stability of the CCJ. Welcome, and I can assure you that you have joined one of the most collegial group of persons in the entire world. Thank you very much.
Justice Anonymou.
So much. I really express heartfelt thanks to the President and to my colleagues, Justices Anderson, Ashnorth Lee, and Burgess, for their very warm welcome to my first sitting. It really is an honor to serve as a judge of our esteemed Caribbean Court of Justice, alongside such eminent colleagues, and as my sister would have recalled, as the third woman behind herself and the Venerable Justice Desiree Bernard. It really is a privilege to serve the people and states of the community as a judge of our region's highest court. I take very seriously the responsibility to adjudicate cases fairly and justly, and the responsibility to contribute to building Caribbean jurisprudence. And so I just want to close by reiterating that I pledge to work assiduously to ably discharge this responsibility, starting from the case we are about to hear. Thank you so much, everyone.
Thank you. Madam Deputy Registrar, maybe you may call the case.
Thank you, President. Caribbean Court of Justice, appellate jurisdiction, an appeal from the Court of Appeal of Belize, hearing of appeal in BZCV number 2 of 2024 between New Deal Limited and Arturo Matus, Registrar of Lands and the Attorney General of Belize. The members of this morning's panel are Mr. Justice Saunders, President and the Presiding Judge.
Good morning again, Counsel.
Mr. Justice Anderson.
Good morning, Counsel.
Madam Justice Rajnos Lee.
Good morning again, everyone.
Mr. Justice Burgess.
Good morning, Counsel.
And Madam Justice Ononewu.
Good morning, Counsel.
May we have the appearances, please? Thank you.
May it please the court, Naima Barrow appearing on behalf of the appellant, New Deal Limited.
Yes.
My friends Darrell Bradley and Kim Wallace appearing on behalf of the first respondent, Arturo Matus, and Samantha Matut appearing on behalf of the second and third respondents.
Yes, thank you very much, Ms. Barrow. Are you ready to? Sorry?
I do apologize. I just wanted to put on the record that Mr. Graham.
Apologies, Mr. Graham. Apologies, Mr. Graham, as well, appearing along with Ms. Matut for the Attorney General of Belize, representing the second and third respondents.
Yes. And Ms. Matut, you'd have to close one of the microphones. Okay. Ms. Barrow.
Before we launch into proceedings, President, may I take the opportunity to welcome Justice Ononewu on behalf of the Belize Bar and thank her for her willingness to contribute to the development of the Caribbean jurisprudence from a seat on the CCJ. Welcome.
Okay. So who makes submissions first for the appellants?
I will.
Is that you, Ms. Barrow? Please proceed.
The only attorney appearing on behalf of the appellant,
I see.
Mr. President.
Yes.
It is common for people to say that the case is simple, but it is a position of the appellant that this case is simple. It is a case involving claims of riparian rights, and the appellant, who resists the claim being asserted by the first respondent, is of the view that the physical and geographical realities of the first respondent's property render it impossible for its boundaries to have been in contact with the flow of the river for a great part of every day, as is required to establish riparian rights.
Ms. Barrow, before you develop that submission, I just wanted to clarify something. On Parcel 4105, is there any right of access to a public road or a public way other than towards the Belize River?
No, Judge. Oh, no, there's no public access.
Okay. My understanding is that the Court of Appeal had indicated in their reasoning, it doesn't seem to be part of the order, but they had indicated fairly unambiguously in their reasoning that my understanding was that quite apart from the issue of riparian rights, that the respondent was entitled to an easement. Now, there wasn't any appeal against that finding. And I just want to be clear as to what is the position of the appellants in relation to that finding.
Judge, our position is that the first respondent took Parcel 4105 with the situation as it is, with it being landlocked. If I may share to the screen the map of the property, which I think will help. Is it being seen?
Not yet. And it doesn't look as if it's coming up.
Okay, let me see.
Is that the cadastral sheet, Ms.
Yeah,
Barrow?
yeah,
Okay.
yes,
Thank
yes,
you.
Judge.
Yes.
Let me see.
What page is it?
It is on page 543 of the record within my submissions. That's easier. There we go. I am hoping that you're seeing it now.
Yes.
Okay, what I have done is taken the liberty of inserting some color to help the court to see what are the properties in question. In green are the appellant's properties. In pink is the property that was given or sold to the appellant that is the subject of these proceedings. And in blue is the river. In yellow is the first respondent's property.
That's 4106 in yellow.
4105 in yellow.
Oh, 4105 is yellow. Okay,
Yes,
and the green to the left of it.
Is the appellant's property, and the green to the right of it is the appellant's property.
Mm-hmm. But there's a
I
property below that 4105, Ms. Barrow. 4106.
Yes.
Okay, you didn't share that. Okay.
I'm sorry, and I ought to give him this question. 4106 is the property below it, which also belongs to the first respondent. That is the property with access to road.
Okay.
So at the time,
can I just ask, and if the property shaded pink is the 5031?
5031, indeed.
Your client's property.
My client's property is, well, my client's property until the declaration that was made by the Court of Appeal.
That's what I meant, yes, originally. Yes.
Yes.
So
yes.
that property shaded pink is what was known as the reserve?
The parts of it, yes, Judge. Part of it, yes, parts of it were known as the reserve. What the Court of Appeal has ordered is the pink in front of 4105 be excised from my client's title.
So as far as what you're showing us is concerned, Ms. Barrow, you would concede that the first respondent's property seems a bit surrounded, wouldn't you say?
It is indeed so. It is indeed so. And it was from the creation of the parcel. And I think that is the other thing I want to take the court through. I had summarized in the pertinent facts of this case the time of the acquisition of the various properties.
But a question remains on the table, though. And sorry, I don't want to rush you, but the president's question is only tangentially relevant here. I think what he was asking, I'm sure you recall the question, has to do with your response to the reasoning in the Court of Appeal, which seemed to suggest that the owner of the yellow shaded property there had an easement to the river. And I think what we're seeking to understand is your reaction to that position taken in the Court of Appeal. I'm not sure it shows up in your grounds of appeal, for example. And I think that is what we're trying to get at. Yes.
It did not show up in the grounds of appeal because what we say is that our understanding of the Court of Appeal's decision is that there was an easement of necessity argued down below. There was no determination made on that point because it was all taken care of with the determination made in the first instance that 5031 was not that the first respondent was not entitled to the riparian rights being asserted. The position was that 4105 was given with it being landlocked, and the first respondent took it that way and always accessed public roads through its other property, 4106.
And that was the nature of the evidence? I'm sorry, President, yes.
No,
yes.
Go ahead.
That was the nature of the evidence, Ms. Barrow, before the trial judge, and if so, just direct us to the page, if you may.
Sure, Judge. It was indeed the nature of the evidence before the trial, Judge, and I think there was evidence that the house of the first respondent straddled both properties. Let me find it for you, if I may. May I stop sharing this?
Yes.
The map?
Yes. President, could Miss Barrow
Sorry.
have fully file the one as it has the shadings? I think it's most useful, President. We already have a copy of the cadastral sheet, but if
Right.
she
Is there a
could
page number? Ms. Barrow, what you just shared was filed?
No, not the colored version. I colored in page 543 of the record. What I had extracted from the exhibits to the affidavit of Wilbert Valleros. The entire parcel index map is located at page 461 of the record. But I can definitely undertake to file this colored coded version if it helps.
Yeah. Mr. President, if I may, Ms. Barrow,
Yeah, sure.
Might it help if you identify the small portion, this small sliver of the pink, I think the color is pink, in front of 4105, because it's seeing the pink running from one side of the property right across to the other doesn't really identify for us the exact.
I can and I will reshade.
Yeah, thanks very much.
I will treat the rest of the property as my client's property because that is what it is.
That is what it is, exactly. And that's not in dispute. Thank you.
Thank you. The question about whether or not the first respondent had access and the way the first respondent accessed public roads. And I should indicate, and I think I did in my submissions, that the claim originally was a claim for prescriptive title by the first respondent. The first respondent originally claimed prescriptive title to that piece in front that separates his property from the river. That is what he claimed originally. There were determinations made and the claim did not go all the way through. But the original claim form, well, the amended claim form that was the substance of these proceedings had a claim for prescriptive title. He was claiming prescriptive title to that property. It was accepted that the time frame did not permit it. If I may turn to the evidence of the first respondent. And I think maybe I should turn to my client's evidence first in the proceedings below. That is found at page 474 of the record. That's where it begins, the evidence of the appellant.
474.
4. Turning it up. Paragraph, sorry, I said 474. It's coming up on my record now as 472. I don't know why. It may be, I have the index of it as 474. It's 472, apologies, Mr. President. 472, and where the relevant parts of it start is paragraph 6 on page 473. In early 2007, I was no longer able to gain access to parcel 164, which I then knew only as an island because Mr. Arturo Matus Sr. placed old piles in the soft, low-lying area the tractor used to pass to parcel 164. So what it was is that the appellant owned one piece of property and used to pass through soft muddy area to the other piece of property. The first respondent was given title to what is now parcel 4105. and put down
Yes, what paragraph? Sorry, what paragraph again? You said that is
paragraph 6 of the witness statement of the appellant's representative, Mr.
Right.
David Quito.
Yes.
When I inquired of Mr. Matus Sr., who was the only person that frequented that area at the time, about my ability to gain access to the island, he jokingly told me that I would need to build a bridge.
There.
After having access to the island restricted, I continued to cut all the property I was then able to access, which I now know includes parcel 148, 149, and 5031 until 2016. In 2016, the company started construction on parcel 149, and I was transferred to work at Quinto Industry, and that is the representative. But what he's giving evidence of is that initially, New Deal owned the two parcels and had access through what became parcel 4105 from parcel 149 to 164. If I can bring up the map again, it might help for the court to understand.
That would be helpful, yes.
So it is, there we go. So the appellant had access from this property to the other property before parcel 4105 was given or sold to the first respondent. This property over here used to be an island, is the evidence of the representative from the appellant, until this silted up and became property given to the first respondent. So all of this is the property of the appellant. This too was the property of the appellant. This silted up and was given or sold to the first respondent. So that is the history.
Counsel, if I may.
Sure, Judge.
Yes, this is all swampland, isn't it?
Not anymore.
Well, I mean at the time.
Yes, it was, as the court is aware, Belize is low-lying, and a lot of land is given in what looks like swamp. Mangroves are filled in. Not to give evidence from the bench, but from the bar, but to explain that all of this along the river would have been close to water. Some argue underwater, and when land is given there, it's filled in and becomes land proper.
Thank you.
Ms. Barrow, before you go on, if you could put back up the map just very, very briefly, because you gave us a little history of 4105. But what about the property that your client acquired, 5031? What was the brief history of that? Because he didn't acquire that until 2014, is that right?
That is the timeline as I have it. Let me confirm.
Yes, yes. Thanks. Just give us a very, very brief history, please.
Sure. So the history is found. Let me share again. The history is found at page 538 of the submissions. So in 1982, my client got title to parcel 149, which is this one. These are properties along the highway, the highway that leads out of Belize City. So my client got title to parcel 149 in 1982. In 1982, he also got title. They also got title to parcel 164. This property over here, that was at that time to him, to them an island. In 1983, got title to this. I think that is 148. Let me be very certain. So within a year, he got title to those properties. All of these properties here, 1982, 1983. Title to the property shaded in green. In 1987, the first respondent got title to 1335, which is this other property here. It also wasn't shaded, and I will rectify that in the shading. But 135 is what the first respondent got in 1987. In 2003, he got 4105. In 2005, he got 4106. So
But
when he originally,
just a minute, Ms. Barrow, between 2003 and 2005, what was his access?
Judge, I can't say, because if he got access to 4106, then I would presume it would have been through the river. I don't know. I can't say. I can't say, Judge. But on the map, it was landlocked because 4106 did not belong to him. 149 belonged to my client. 164. So when he got it, it would have been landlocked.
Say for the what he called the reserve, that pink between him and the river.
Right. And 4106, he got 2 years later. This property here that gave him access to the road, he got 2 years later.
Yeah, but see, we come back to the first question that I asked. There is evidence that the Commission of Lands, I think, says that every parcel must be sold with some form of access. And if that's a correct statement, then in 2003, when he acquired 4105, there must have been an understanding that his access was over that sliver of pink and to the river. Isn't that logical?
Yeah, well, I will go and look for it, Judge, and probably give it to you at the time of my reply. But I think all of 5031 was accretion that took place after. It was all along the river bank, and it accreted over time. I will go and look for it. But I think the evidence is that much of this was swamp as well, as my learned Justice Burgess asked. All of this was swamp. So the access would have been through the river. If that is deemed public access, then that's what he would have had. Not access to roads, but access to a river.
Right.
And I think that access belongs to anybody who accesses government land. I think the learning is that the foreshore gives persons access, a right of access to the public in general. Where the foreshore is of a river. I think that would have been the foreshore at the time. So he would have had access that way, indeed, Judge.
Yeah, Ms. Barrow, before you take down your very helpful plan, that pink area in front of 4105, is it?
Yes, Judge.
Was that ever, I may have missed it, was that ever measured? What are we speaking about?
The parties have accepted that was 44 feet of land.
44 feet. Yeah.
44 feet.
Going from 4105 to the river, or
yes, to the river.
Okay. Not going. Okay. But was it ever measured like in square feet or something? How much are we actually speaking about?
that is how we measure. The entire area, I don't know, but the distance from the boundaries of 4105 to the river has been accepted as being 44 feet.
Thank you.
To help you, I did some calculations and conversion. It amounts to the average of 8 people, 5 feet 10, lying one in front of the next in terms of visualizing it. I had to do it myself. How wide is 44 feet? So it's from the edge of his property to the river is 44 feet. The parties are agreed upon that. They've agreed it from first instance.
Thanks a lot.
Sorry, you said that 50, parcel 50, the area shaded in pink, you said that represents accretion over time, correct?
I think that a portion of it may have been accretion because that was the shore of the river.
And so at the time that 4105 would have been acquired, there would have been some accretion that would have existed at that time. In other words, there would have been some kind of foreshore at the time of acquisition of 4105.
I think it's a reasonable presumption to make, George. I think so. I think so.
Yes, proceed, Ms. Barrow.
So before we come off the point, I want it to be made clear that when 4105 was acquired, it was landlocked. That is our position in relation to all of these things, that it was landlocked, and the first respondent has access to the public roads through his property now.
All right, so tell us why you think that the Court of Appeal's decision is in error.
Well, the Court of Appeal felt that it is possible for riparian rights to exist over land that you do not own. And our position is that was their ruling, that a strip of land belonging to a separate landowner interposed between your property and the river affects your claim for riparian rights. If there is property between your property and the river that makes it so that your property does not come into contact with the river for, I think the wording is for a part of the day, then you do not have riparian rights.
But your land, Ms. Barrow, your land might not come in contact with the river, but the river might come in contact with your land. So I think the number of it is the claim is on the premise that the river does in fact flow into the subject land, and it does so on a regular enough basis for the owner of that land to be regarded as a riparian owner.
Well, I think the regular enough basis is important. The learning says it must come in contact for a great part of every day in the ordinary and regular course of nature. And I think this is where it is important to understand that your boundaries are established with regard to what the ordinary tide is. What the ordinary tide is. Not high tide, not low tide, but the ordinary tide.
Ms. Barrow, what do you understand the ordinary tide to be?
Judge, I have gone through a lot to try to get a proper understanding of it, because it's based on the tide and the moon, and it took some understanding, but it is where the water sits, where there is no high tide or there is no low tide, depending on the time of the month, the moon and the tides. That is where it is, based on where it is ordinarily in the absence of there being a high tide or a low tide.
And that proposition that you make about the ordinary tide, that I think you said that the boundaries of 4105 would have been fixed at the area where ordinary tide was. What's the authority for that?
It's a recognized provision. I think it's section 48 of the National Lands Act is what the first respondent relied upon in
28.
I think it's 28 or 48. Is it
28? Is 28, I think.
Thank you, Judge. It's a proposition that he accepts, that the first respondent accepts in his submission.
Counsel,
Yes, Judge.
is it too simplistic to understand ordinary tides as meaning the mean of the high tides? It has nothing to do with low tides, but it has to do with high tides. High tides are higher sometimes than other times, but the mean is of the high tides. Isn't that what, would I be being too simplistic?
Judge, if that is the case, that would help me to understand it greatly, because that was never so simply put in any of the authorities I found. But I would accept that as being what it is. But what I know, what I am certain of, is that the boundary of property is established in relation to what the ordinary tide is. And the evidence before the court is that at high tide, at some points during high tide, the river may have washed onto the first respondent's land, but it is not the regular placement of the river.
What did Ms. Barrow, what did the High Court judge make of that? What did she say? Because you appeal especially on ordinary tides, and what is the high? You said it's not high tide; it's the high water mark at ordinary tides. I believe that was one of your grounds of appeal, that the Court of Appeal got that wrong. Yes. What is the judge? How did she look at that evidence, and what did she make of it?
I think it was accepted that that is the position because of the provisions of the National Lands Act. And if I can, I will bring up the judgment of the decision of the High Court.
Yeah, what I'm asking is, did she accept then that at ordinary tide, if I may use that term, I'm not sure, or tides, that the Belize River came onto the first respondent's land?
At ordinary tides or at high tides?
Well, no, you speak about ordinary tides and you say that is the test.
No,
Am I getting you right? Yes.
You are getting me right. The assertion was never, it has never been, up until the reference to low tide in these present submissions, it has never been that the tide of the Belize River came onto the first respondent's land during ordinary tide. The assertion has always been that during high tide, it came on sometimes. It was not accepted.
Counsel, sorry. You're challenging my understanding of tides. I thought that there were basically only two tides, high tide and low tide. High tide, one high tide may be higher than another high tide, but as I understand it, you have 4 tides in a lunar day, 2 low tides and 2 high tides. That's my understanding, but sorry, up until now. So that the ordinary tide is a concept which is dealing with the high tide. The fact that you have higher high tides on one occasion than on other occasions, and the mean high tide, not low tide, mean high tide is what is the ordinary tide. Am I wrong?
I don't know, Judge, and I will clarify it now, because I thought it was the difference between the high tide and the low tide. It's the average between those 2 points that gave you the ordinary tide. I'm not sure if that is an oversimplification of it. I don't know. I only had reference, and I was looking in the Interpretation Act and combing for where they describe what the ordinary tide is. So it's when the river is neither high nor low is the ordinary tide. That's what I thought it was. That was my understanding of it.
I suggest that we have a look at the authorities on tides and see if that's correct. Thank you, nevertheless. Thank you very much.
I would agree with that, and I look forward to doing that. But just for my clarification, could it just be very clear? Are you conceding that on a daily basis, the water from the river comes onto the land of the first respondent?
Not at all.
Or
not at all.
Are you saying that during the course of a day, the water may not at all come onto the land of whatever tides you call it, ordinary, low tide, high tide?
That is precisely it, Judge. That is precisely our contention, that it is not in contact with the property of the first respondent, on a regular, ordinary day, it does not come in contact with the property of the first respondent.
And is that a finding of fact? I think my sister was alluding to this, to which you can point us in the court, the High Court's judgment. Was it a finding of fact made by the High Court judge?
I will look for it, and I believe so. I will pull it up right now if the court would permit me to do so. It begins at page 230 of the record, and I am going there now. Of the record. Crave the court's indulgence, please, so I can find. If I may. Apologies, Judge. I'm trying to find it in this record because I have it. Otherwise, let me find it where I can and trace it. Apologies, Judge.
Is it in a decision at paragraph 126?
Thank you. I'm trying to pull up the decision in these records because I've been working off the other one, and that is my.
126 following.
One, 2, 6. 127.
You see, one might infer that is what she's finding, but she's not very definitive.
I do not find, based on the evidence before me, that the claimant has established that he had any riparian rights over the open space. And sorry, I'm reading from paragraph 127 of her decision. That portion of land between parcel 4105 and the Belize River, as parcel 4105 does not abut the Belize River or Hollover Creek on its northern boundary.
And then she goes on to deal with prescription.
Yeah.
Right.
That is not definitive of what I was trying to get clarified, I'm afraid.
He has only owned, if you read further in that same paragraph, he has only owned parcel 4105 since 2002 when he acquired title for that parcel from the government of Belize, and parcel 4105 abuts the open space on its northern boundary. It does not abut the Hollover Creek or the Belize River. And I think it's important at this point in time to turn to the evidence of the first respondent himself, where he speaks about the use of what was being referred to as the open space that became parcel 5103. So by his own evidence, he used to walk on that property. It was not that his property came in contact with the river, but that he used and built on 5103 to gain access to the river. So if we turn to the evidence of the first respondent himself, I think that might help.
Well, the evidence is useful, but the legal proposition is what intrigues me, because one test is that the land must abut the river in order to gain riparian rights. Huh? And I think that's the test on which you are basing your argument.
Yes.
But there's another theory which suggests that as long as the river comes into contact frequently with the subject land, that landowner can also have riparian rights. And that's a legal theory, I think, on which the Court of Appeal seems to have based this decision. Now, you may or may not concede the point, but to me, it seems that to put a full stop on this from your end, if there was evidence that the water from the river did not come into frequent daily contact with the land of the first respondent, that would be an easy way to button that up. But you can't seem to point to us any passage in where there's a factual finding that that was the case. The paragraphs you're pointing out are premised on the first legal theory, that is to say that the land did not abut the river. And even if you accept that, I'm saying that that still leaves open the possibility of riparian rights. If you accept the second theory, that is to say that the water from the river comes into daily contact with the subject land. Do you see the difficulty I'm having?
I think that the important thing is the frequency of the contact. It is not sometimes, because in tidal rivers they move, so we don't accept that it comes into contact with the river sometimes. It's the frequency, and it must come into contact with the property in question every day. Every day.
The last sentence in 127, which only raises a presumption, and perhaps we need to look at the evidence to see the extent to which that presumption is made out or rebutted. But it seems to me that what the judge is saying there, that since the boundary for Parcel 4105 is presumed to be made with reference to ordinary tides, then that is indicative of the fact that it is only in an extraordinary time, when the tide is particularly high, or when, given the movement of the earth in relation to the moon, or the movement of the moon in relation to the earth, that water would come onto Parcel 4105. Because other than that, we have to presume that that doesn't happen, because the boundary was made with reference to ordinary tide. That seems to be the best argument that you could make so far as what the judge actually says.
And it has been our position, Judge, because to our understanding, the high tide and the ordinary tide were two different things. That the ordinary tide is how you establish a boundary of your property with 44 feet between your property and the river. There is sufficient land interposed between your property and the river. While he claimed by himself prescriptive title to that property, it was his means of linking himself to the river. The original claimed prescriptive title over the property. It was not a version that property did not exist. That it came between his property and the river was never in dispute. What he claimed was, sorry, George.
Well, Ms. Barr, if we return to paragraph 127 of the High Court judgment, to which President Saunders was just drawing our attention, there is a part of the final sentence that I find quite striking, and I'm wondering if you can help me here. The trial judge indicated that even accepting that the Belize River was present on the claimant's land during high tide, Section 28 is inapplicable because it provides for boundaries in reference to ordinary tides. My question is this an indication that the trial judge was dismissive of the relevance of the river being present on the claimant's land during high tides?
I think she feels, I think that yes, that it doesn't matter because high tides aren't every day.
Is there anything in the record that would suggest that the presence on the claimant's land of the river during high tides would be irrelevant in understanding whether the river actually abuts the claimant's land? In other words, no one is disputing that there is intervening land between Parcel 4105 and the river. No, I don't think anyone is disputing that.
No.
I think what is important here is to understand, if notwithstanding the presence of that strip of land, there could still, riparian rights could still arise if during the great part of the day, the river actually makes contact with Parcel 4105. And that's why I'm trying to understand if you think in any way it's significant that the trial judge seems to be dismissing the relevance of the presence on the claimant's land of the river during high tides.
I think so, for the reason that it was never asserted, the assertion was never that the river comes in contact with the first respondent's land every day. That was never the assertion. It was never the assertion. It was that during high tides, and high tides, by their own evidence, is not every day that the river comes in contact with their property. If that were so, then as a matter of fact, evidence would have been adduced as to how far and how high the river rises. Or position.
But counsel,
I have a sense Justice Burgess might want to follow up on what you're saying.
Yes, I have a slight difficulty when you say it doesn't come on the land every day, if it comes at all. Now, high tide, as I understand it, is part of a system, a lunar day system. Every 24 hours and 50 minutes, I think, is the time. You have in between that time 2 high tides and 2 low tides. This happens on a lunar day, which is basically an Earth day with 50 minutes added on. So it is impossible, if the river is coming onto the land during high tide, it is impossible for the river not to be coming onto the land during high tides. Tautologists, I know, but it seems to be true. I do not think that we are correct to view high tide as a special event. Am I right in addressing it that way?
I am trying to digest, because and I confess that my understanding of how high tides work separate from ordinary tides. In my head, when high tide happens, it's not a daily thing, but something happens, the flooding of the river, those things make the tide come up higher. If the ordinary tide is in reference to the average, position,
the
mean of the two tides, is it that every day then that the river would go to its highest high tide?
Sorry, I don't purport to answer that question, Council, but my limited understanding is that you have 2 tides, high tide and low tide. These are the only tides that you have. The high tide is higher some days than it is on other days, other occasions. When we talk about ordinary tides, it has nothing to do with low tide. What it has to do with is the high tide. The high tide at its highest point and the high tide at the mean point. That's what I think I understand by ordinary tide and high tide. So in following up on a newest observation to you, it would appear that if one accepts that the river is a tidal river, then it is subject to the rules, the physical rules governing tides, so that there'd be daily contact. It's not like flooding. It's the tide rising and the tide falling. Council, that's what I think I should understand. Am I right?
I understand what the court is saying, but I am saying that what was the evidence before us in the proceedings, the understanding of tide not being as clear as it is now. It's coming home clear to me what the evidence was from the first respondent himself was not that water came in contact with his property every day. That is what the evidence is, that it did not come in contact with his property every day or a great part of every day. That was never the evidence before the court.
But we see what was the evidence before the court.
The witness statement of Arturo Matus, I think beginning at paragraph
what
5,
page?
Page 4. I have it as page 415 of the record. Let me just confirm, Judge. Or 15 of the record. His witness statement.
Yes, it's at page 415.
415 of the record.
Yes.
And he speaks with reference to the construction repair. Let me get the exact paragraph. I think it's paragraph 6. Paragraph.
Yeah, what he says in paragraph 6 is not exactly what you're suggesting. He says Parcel 4105 was always riverfront, and the reserve was simply the distance between the high water mark and the low water mark, as measured by the surveyor. At high tide, the water from the river came all the way up to the edge of Parcel 4105, and sometimes the water from the river went into 4105 as much as 10 feet, and at low tide it receded. Maybe what you want to look for is his cross-examination, that is done on him.
More precisely, Ms. Barrow, it would be helpful if you could give us a sense as to whether the record ever established that the river made contact during the day with Parcel 415 during high tide. Whether that was ever disputed on the record, that there was contact between Parcel 4105 and the Belize River during the ordinary course of the day at high tide. We understand that there may be distinctions about what that means, but I think if you could help us in that regard, that would be really useful.
I will. There was contradictory evidence from the first respondent as to the status of his property as it relates to the river. And I'm trying to pull it back up now. In his second affidavit in support of the fixed date claim form, page 506 of the record, the evidence is different. So as a matter of history, the proceedings, there was an application in terms of that an application to strike out the claim based on the claim of prescriptive title of that parcel in between, and so the evidence shifted. We say, if you go to paragraph 7 of the first respondent's second affidavit in support of the amended fixed date claim form, found at page 506 of the record. So this is the affidavit in support of the fixed date claim form. He said in paragraph 7, since my carrying out of the survey in 2002, I exercised full occupation, possession, and control of all land described as Parcel 4105, up to and including the water's edge, and including a portion of the area designated as a reserve in front of Parcel 4105, and up to Hollover Creek. I considered this area of the reserve part of my land. I had constructed a dwelling house on Parcel 4105 and filled the entire area, including this portion of reserve. And I erected a docking facility and pier along the water's edge in the reserve to moor my boats. And I maintained this area by regularly cleaning the reserve and repairing the pier. So the evidence that supports the original claim was that he took part of the reserve and treated it like his land. So when he says it comes onto his land, it was because he filled in part of the reserve and treated that part of the reserve as his property. That is the original claim. Proceedings developed and the claim for prescriptive title was abandoned. And so the story became a different one. That was the inconsistency in his evidence. So what his evidence was when he originally framed his claim is that he took in part of the reserve as his property as well. What he sought to allege is that he took it in so long that he got prescriptive title. The rules and the laws that relate to prescriptive title of for sure is different. He did not have the requisite amount of time. But what he gave as support of his original claim is that he took in 4105 and the reserve and filled in the reserve and treated the reserve like his. So when he built that pier, it was knowingly in the reserve that he was treating as his own property. That is the inconsistency in his evidence. I had always considered the area of the reserve in front of Parcel 4105 and going to the Hollover Creek as my land, and this area of the reserve was contiguous to my land. Based on the foregoing, I assert that I have enjoyed peaceful and open possession of a portion of the reserve in front of Parcel 4105 up to the Hollover Creek from 2002 to 2017, and I have thereby acquired title by prescription, and further, or in the alternative, the government and the third defendant's title to the area have been extinguished. I further assert that I have riparian rights of egress and ingress along the banks of the Hollover, as I would regularly use this reserve area to access the waterways and to swim and to fish. So his original claim was that he treated the reserve as his, and that is how he established his property's connection to the river.
Was there any cross-examination of this contradictory evidence?
There was. If I may bring up the transcript, which is found at beginning at paragraph pages 315 of the record. If I may. Trying to find that. Page 315 of the record. Sorry, page 230 of the record. 350 is a transcript of the proceedings. No, it's 315. I'm sorry. Yeah. I'm getting it confused. Let me.
Maybe at 321?
32. Thank you, Judge. I'm confusing what is coming up on my page is the two different record numbers, and so I'm getting the correct one.
It's 24 of 106 and then 321 of 43.
Obliged. I recall he was dismissive of the significance of the reserve. Let me find it. 321. As is the nature of these things. 321. Thank you, Judge.
It goes on for quite some way.
Yes.
Distance. The cross-examination actually starts at
Complete,
325.
Right.
The cross-examination starts at 325.
Obliged judge. Cross-examination. The reserve comes at this is where he gave evidence as to his use of 4105, that he uses it to park his boats and to launch his boat. We built a boat in the yard before. So that was his use as to 4105 as being contiguous and with the other parts that he had his house on. 41149 west side.
The cross-examination about the reserve starts circa page 339 or so.
Obliged, Judge. If we can go back to page 337. He said at the end of it that he built his dock, showing him a picture with his fence, and he said it was it's about the picture there that has his fence, and that's in the record as well. He says the fence and my pier right here, these pillars are part of my dock, and so the space between that is about 5 feet, maybe 8 feet. When the tide comes, all that becomes water. So it is about 5 feet from the fence to the dock is, and the question in terms of the spacing.
And the dock is right on the river's edge.
And that is the evidence he gave, that he built the dock in what was the reserve. I received to survey. I asked if there was a question as whether or not he would agree that there's a 40-foot reserve between his property and the river's edge, and he said he wasn't sure because he didn't measure it. But that's what his surveyor told him.
Miss Barrow, on page.
Sorry, Judge, just so that you can get clear his attitude towards the reserve. Line 15 on page 339. In response to the question, so you would agree that there's approximately a 40-foot reserve between your property, your border, and the river's edge? Yes, Mr. Samuels told me that there is a reserve there and that he can't give me any further because that's reserve. He couldn't give me title for it, but it's mine because it's my reserve. And he accepted, he said because of his surveyor, it's because it's reserve land, he couldn't get title to it, but he treated it as his property.
Ms. Barrow, what I wanted to just get some clarity on is during the cross-examination on page 340, the question is put to Mr. Matus, I'm now around line 4, or above line 5, I'm sorry. It says, so then with this admission, would you agree that your property does not touch the river's edge? His answer is, with high tide, the water comes right up to the fence. What's the significance of that?
The evidence, and I want to be clear that the evidence that he gave is that that fence and all that was built on the reserve.
The fence was built between the the main river and the reserve, or between the reserve and 4105, or somewhere in the middle?
His evidence is that he filled a portion of the area noted as a reserve to better utilize the river access and prevent erosion of Parcel 4105. And I erected a docking facility and along the water's edge in the reserve area to moor my boats. And I maintain the area by regularly cleaning the riverbank reserve. So the use of the reserve as his is where the confusion arises. He erected his pier, he built his dock in the reserve. So what is touching and what he treats as his land, he treats the reserve as his land. So when he talks about it coming up to his land, it is the reserve that he has filled in and treated as his land, even though it's a government's reserve. That is why his claim is for prescriptive title, because he was exercising these rights in relation to government's land. That is where the confusion arises.
So it is your suggestion that on those occasions where he says that at high tide the water would come into his land, he may well be talking about the reserve.
It was the reserve area. It was the reserve area that he's treating as contiguous and a part of his land that he couldn't get title to. He filled in all of that, built a dock, and he was treating it as his property. So when he says it comes onto his land, if the water comes up, he says 10 feet, sometimes more into the property. 10 feet doesn't take him to the 44 feet to his boundary. By his own evidence that sometimes the water comes up 10 feet. It's 10 feet into the area that he has filled as his property, which wasn't really his property. That still takes him 30 feet from his actual property boundary. By his own evidence, it's not enough. His evidence is sometimes the water comes up 10 feet into his property, but he has filled in the reserve, which is accepted as being 44 feet between the boundary of his 4105 and the river. The property, if the river comes up 20 feet, it still doesn't put him in touch with the boundary of his property by his own evidence. The concession made is that there was a 44-foot reserve. His evidence is that he filled that in and treated it as part of his land because it was contiguous to his. That he was under the impression from his surveyor that while he can't get title, that is his reserve. The reserve was never his, Your Honors.
President, I think we all follow what Ms. Barra has said.
Yes, I think you should move on.
Yes, thank you.
Thank you.
Actually, you're running out of time.
And I did not expect to be talking this long. I did not see these questions coming. I am grateful for them, and I understand where the court is. The position is simply as a matter of fact, Judge, that Your Honors, that there is 44 foot of land between what is the proper boundary of the first respondent's property and the river. That 44 foot of land belongs to the government of Belize, belonged to the government of Belize before they sold it to my client. Having sold it to my client, there is no right that the first respondent has, no riparian right that he has to disavow my client of the title that he has purchased from the government of Belize. That there's no special abutment that takes place to establish riparian rights. That is the implication of what the Court of Appeal decided, that he abutted, that the first respondent's property abutted the river so as to establish riparian rights. It either as a matter of fact abuts or it does not. There is no special abutment that takes place. It is a matter of fact. Or
I think that might be the nub of it, Miss Barrow. Your theory of the case is that given that this, let's call it reserve, there's some disputes about that, but given that there is a reserve between the sea and the first respondent's land, he has no riparian rights.
As a matter of geographical and physical properties, it's impossible to establish.
Okay, But and I understand the case that you put forward, but if as a matter of fact, the river did come into contact with his land on a daily basis, would your position be different?
Absolutely recognizing that his land does not include the reserve.
Yes.
Recognizing that his land is 44 feet away from the river.
Understanding all of that.
I accept all of the principles, Your Honor, and I'm not saying anything other than it did not, as a matter of fact, come in contact with his property. If it did on a daily basis, then if contact is established as a matter of a daily thing, then there can be no dispute as to the riparian rights.
Okay. Thank you.
The 44-foot reserve did not belong to the defendant, to the first respondent. It was not his. And though he treated it as his, the 10-foot that he speaks about the water coming up the tide, moving it 10 feet onto what he thought was his land, which is the reserve that he filled in, did not put it in contact with the proper boundaries of Parcel 4105 so as to establish riparian rights.
I think we follow you, Miss Barrow,
Yes.
on that. Thank you.
And that is the substance of the appellant's position and submissions. Thank you so much for the time afforded.
Yes, thank you. Thank you very much. Let's take a short break here and we'll come back at, like my watch is 12:21. So we take a 9-minute break.
Obliged.
Obliged.
Yes, so we're back. Which counsel will begin the arguments for the respondents?
For the first respondent, Darrell Bradley.
Yes.
If Your
Please
Honors,
proceed.
please. Sorry, thank you. If Your Honors, please. The first respondent opposes the appeal, and the first respondent asks this Honorable Caribbean Court of Justice to dismiss the appeal and affirm the decision of the Honorable Belize Court of Appeal. Mr. President, Honorable Justices of the Caribbean Court of Justice, I want to begin with the evidence and a point that my learned friend had concluded upon in engagement with Your Honors. And this is the evidence of whether or not the water came in regular contact with the first respondent's parcel of land. And it would be our position that the evidence was actually clear that came out at the first instance court that the waters of the Belize River did in fact come in regular contact with the first respondent's parcel of land. We would invite Your Honors to consider first and foremost the paragraph 6, page 14 of the record. This is the witness statement of the first respondent at the last paragraph. This is where there was a bit of questions on this when my learned friend responded to Mr. President on the engagement, where he explains that at high tide, water comes up to as much as 10 feet onto Parcel 4105. And he's very, very clear in relation to his reference to Parcel 4105. He's not speaking about the reserve. So he makes it very clear in his evidence.
Just a minute, let me find, allow me to find that. What page number is it you said?
It starts at 415. This is the witness statement of the first respondent, Arturo Matus. And I'm referring specifically to paragraph 6 of the witness statement. This is the last sentence of paragraph 6.
Page 415.
So this is paragraph 6 of the witness statement of Arturo Matus, and it's the last sentence, at high tide.
I think I inadvertently closed. But go ahead.
So we just want to place the evidence that the evidence at trial was very clear and there was no dispute. And we believe that this is why the Honorable Court of Appeal felt circumscribed in saying that the uncontradicted evidence was. And so it is our position that the evidence at trial, which was not diminished or challenged in any substantial respect, was that the waters of the Belize River came in regular contact with the first respondents, Parcel 4105. And we place that evidence starting at paragraph 6 of the witness statement of the first respondent, Arturo Matus, where he actually says that. My learned friend talked about his understanding, whether or not he was speaking about the reserve, whether or not he was speaking about Parcel 4105. There was engagement on a fence and where the fence was located. One of the points that the first respondent in reply wants to underscore is that those are points for cross-examination. If there is any speculation or misinterpretation in relation to the evidence, it is not for, with respect, the Honorable Caribbean Court of Justice to construe the evidence. It's not for my learned friend to speculate in relation to what was thought or what would not have been thought or what should have come out. That evidence was proper scope for cross-examination. Where is the fence? Is the fence on the reserve? Is the fence on your land? Where is the Where is the pier? All of those pieces of evidence are properly placed in the witness statement of the first respondent. And it makes very, very clear that the waters came onto parcel 4105. That was not in dispute and that was not challenged in the High Court. I want to just build on this point shortly.
Sorry, counsel, just to, again, put a point on this.
Yes.
Is the allegation that the water came onto the land on a daily basis?
Your Honor, the evidence as it came out is that at high tide, the waters came onto parcel 4105 and it came as much as 10 feet onto the property. And that's what is in paragraph 6, page 415 of the record. So that is the evidence that came out. And that evidence was not refuted in cross-examination. There were questions in relation to where things were. And repeatedly, when asked about the reserve, the respondent, starting at page 365, used words like it was wet, it was swampy, it was flat swamp. This entire area was swampland. There were also pictures that were adduced of that area in relation to the quality of the land, that it is land that used to be swampland. And for many parts of the day, it came in regular contact. And now I'm speaking about 4106. 4106 came in regular contact with the water.
4105.
Forgive, 4105. 4105.
But tell me something, Mr. Bradley.
Yes, Mr. President.
You referred us to paragraph 6 on page 416, and I agree with you. That's his witness statement. There's a very clear allegation there that the water came onto parcel 4105. But Ms. Barrow, just before she took her seat, also provided us with statements that he made in cross-examination, which suggest that he regarded the reserve. In fact, he said it. This is my reserve. That is my land. And he suggests there that the water came onto the reserve at high tides. Now, if there is that contradiction between what he says in his witness statement, which is a stilted document which is prepared with the assistance of counsel, and what he says when he's alone in the witness box being cross-examined, given that the trial judge seems to have placed a greater store on the responses in cross-examination, which responses were contradictory to what is in the witness statement, is there a basis upon which one might be able to say that the trial judge's assessment was an unreasonable one?
Mr. President, I would answer in two folds. Firstly, it is not the position of the first respondent that there was any contradiction in the cross-examination. So that I looked at my learned friend's questions and I looked at the responses from the witness, the first respondent. And it is correct, as my learned friend has said, that the claim originally was framed that the surveyor, the first respondent surveyor, put this reserve as a buffer zone onto the parcel of land that was being applied for by the first respondent. So the first respondent's contention initially was that, well, this is my land because this is the buffer zone given as a protection for my land. But with respect, and this is where I would divide from my learned friend in relation to that portion of cross-examination, there was no area in that cross-examination where he's distinguishing between what I'm saying is the reserve and what I'm saying is Parcel 4105. When he speaks about the reserve, he uses the word the reserve. When he speaks about 4105, he says 4105. And so there are questions in relation to the ownership of the reserve, which he says, I thought that was my land. But when it comes in relation to the clarity of the witness statement, there's no impeachment with respect in relation to where the waters rush onto. His evidence, unimpeached, which is our position, is that for the greater part of a day, water comes up to as much as 10 feet onto Parcel 4105, not the reserve. In the witness statement and in his evidence, there are questions and distinctions in relation to which portion of land we're speaking about. The pier or the dock was built by him on the reserve. He speaks of the reserve as swampland, as it being wet, as it being flat swamp. And when he speaks about the water rushing as much as 10 feet, he makes it very clear that it's 4105 that goes on to. So that with respect to the cross-examination, it would not be our position that there would be any contradiction. I understood my learned friend to be making reference to a first affidavit and so forth. The evidence is there, the cross-examination is there. Your honors were going through the sections of the cross-examination, I was reading passages, and I would invite your honors, which I know your honors would do dutifully, to go through the cross-examination, which actually makes it clear. But what I would submit is that if there is any ambiguity in relation to that, that is for counsel, for the appellant to clear up. Where are you saying we're speaking about? There's no clarity. And so on appeal to the apex court, we can't get clarity. In our humble position, it was very clear in relation to the high court. And so the decision in the high court was strictly on a point of law, because there was this thin area of land, we say swamp, between Parcel 4105 and the Belize River that interfered with and negative the creation of the riparian rights. It was never an issue as it relates to the water. That was not something that was canvassed in cross-examination, but the witness statement surely makes it clear.
But Mr. Bradley, even that I'm not sure about. You pointed us to, is it paragraph 6 of the witness statement? And it's not. Thank you. And it's not necessarily as clear as you're putting it. Could you take us there to that paragraph and go 6? To yes and go to the penultimate sentence? That's page 416, I think, of the record.
So it's the last paragraph, sir.
Yes, it's paragraph 6, and towards the end of that paragraph.
Shall I proceed?
Yes, please.
It says, at high tide, the water from the river came all the way up to the edge of Parcel 4105, and sometimes the water from the river went into Parcel 4105 as much as 10 feet. And at low tide, the water receded and more of the riverbank was exposed. But at all times, I had unimpeded access to the Belize River directly from my Parcel 105.
So it seems
to me he's saying a lot of things there. Eh?
Yes,
and,
exactly.
One of the things that he says is that the reserve, that piece of land between the boundaries of 4105 and the heart of the river, was simply the distance between the high water mark and the low water mark. Now, that sentence could suggest that the edge of the 44 feet is normally the high water mark. And of course, the part that is abutting the river is the low water mark. Now, if that is what he intended to convey, then it suggests to me that it is not necessarily indicative of the fact that for the greater part of the day, each day, water would go into 4105, although he does say that at high tide, the water from the river came all the way up to the edge the edge of Parcel 4105, which is consistent with his previous sentence, namely that that part of the reserve which is closest to 4105 represented, as it were, the extent of a normal high tide. And then he goes on to say, sometimes, not every day,
Flooding.
sometimes the water would actually cross that normal high water mark and go into Parcel 4105, sometimes as much as 10 feet. Now, is all of that indicative of a fact that on a normal day, every day, water would go into Parcel 4105?
So there are two, shall I respond?
Yes, please.
So there are 2 points that I wish to make. First is, it is our view that that is indicative of that fact, that the witness places exactly what he's speaking about. He speaks about the water coming to the edge of the boundaries, and he uses the word sometimes it goes all the way up. Then he reinforces that by talking about low tide. So he's placing the entire statement within the context of high tide and low tide, so that he's saying that the water comes all the way as much as 10 feet. Surely it may not come 10 feet every single day. So he's giving an indication in relation to that. But at low tide, the riverbank is exposed, so that it's one statement in relation to his position. The second point that we wish to make on this is that I will concede, in being fair, I will concede that is, I mean, there are indications that could be made either way. That's something for cross-examination. And surely the point was not clarified in relation to, okay, and when you're saying sometimes, what are you talking about? Every week? Are you talking? So what I'm saying is that it is on a balance of probabilities that a court makes a finding. And in relation to the evidence that came out, and we would submit was accepted. And the evidence surely that the Court of Appeal found was that for a continuous period of time, water abutted the edge of 4105. The second point that we would make here is we cite authorities starting at paragraph 12 of our submissions. I believe it's 8 cases. The Court of Appeal cited, I believe, 3 or 4 of those cases, and we went through the facts of those cases, which we consider with respect relevant. And it is not certainly our position that there has to be this daily contact with water in relation to the reference. The reference that we use in relation to Halsbury in particular, and one of the cases, I believe it's the Fishmonger case, speaks about accreted land. And my learned friend actually said and concluded that this was accreted land, that originally this was all swamp. It was an island. And so the land would have silted up and developed over the period from the 1980s to now. And what I would say with respect is that accretion does not interfere as a matter of law with a riparian owner's access and rights to riparian rights. So that the issue of how did this land come into being, the distance in relation to the high water mark and the low water mark, how much of the land, how regular the land was touching with, came in contact with the water. Those are points which my learned friend, if she challenged those issues, should have raised in cross-examination at the High Court. But it is certainly not our position in law, because we would say that we could win the case multiple ways. And if it is, and we submit that it is accepted by the appellant that this is accreted land, if this was once all swamp land and was once an island and it developed over the course of several years, that does not interfere or negative riparian rights. And we would submit that this issue of being in daily contact with the water is not the only way that we could get to the finish line.
Yes,
We would
continue.
invite, sorry.
No, continue, please.
Mr. I would want to just invite the court, because this was a point, and when I went through the judgment, the Honorable Court of Appeal, the Belize Court of Appeal, was very deliberate in relation to, I believe, how they framed the decision. They began at paragraph 5 to set out the record and to set out what was determined. At paragraph 6, the Court of Appeal went into very much detail in relation to the findings of the High Court in relation to the factual nexus of the particular case. At paragraph 12, the Court of Appeal then spoke about what the appellant then's position was, who is the first respondent now. And at paragraph 16, the Court of Appeal of Belize sets out a rather clear statement that in their view, it was uncontradicted in terms of the evidence that the waters did abut 4105. And we would submit that on a reading of the evidence, including the witness statement and the cross-examination, and also including the cross-examination of the representative, Mr. Quinto, of the appellant, and the cross-examination and evidence of the Commissioner of Lands, there is no dispute that this was the parcel 4105 did have water that rushed onto it for a continuous period of time. I want to also invite the panel to consider paragraph 18 of the decision of the Court of Appeal. There was an interesting discussion that went in the Court of Appeal on the evidence of the Commissioner of Lands, because much has been made, and I want to underscore this point, much has been made about this 44 feet. We do agree that the 44 feet is on the title, but we do not agree that that 44 feet was land. So the issue that we raised, and
I don't understand.
So
if it wasn't land, then what was it?
It was water. So 44 feet, so that sometimes when a person does, and this was canvassed in the cross-examination of the Commissioner of Lands, when he was asked directly that if the end of that 44 feet was that in water, and he says sometimes. So that what a surveyor does is that a surveyor would put the 44 feet, and sometimes that 44 feet was in water. And the evidence was in this particular case that that parcel of land was no more than 10 feet in actual land. And in many cases, water rushed onto that into 4105. So that the evidence on this point, we would submit respectfully, is actually quite detailed. And when one
you
looks
have to point
at,
us, you can't just keep telling us that is the evidence. It would be helpful if you could point us to it.
Forgive, Mr. President. I would just want to go then to the evidence of Mr. Vejos in terms of where he talks about, and one of the things that I want necessarily in relation to his particular evidence, because he is not somebody who is very familiar with this area of land. But that question came as a result of whether or not when someone is granted permission to survey land and they put the 44 feet, which is a legal requirement, when they put the 44 feet, is that 44 feet in water? And he says sometimes that's in water. And so the point that we're making here is that there is no evidence that that 44 feet was land.
Mr. Garvey, can you just direct us to the part of the record where the examination of the commissioner you're referring to is taking place? Thanks.
Yes, Madam Justice.
Mr. Bradley, the Court of Appeal referred to it in the last sentence of paragraph 18.
Yes.
But I think it would be helpful to see the context. Thank you.
Yes, Madam Justice, I'm just trying to locate that reference. Madam Justice, if I may just ask, just co-counsel, if co-counsel would just help me to find that particular part of the reference in relation to the cross-examination of Wilbert Vejos in relation to just the quality of land in this particular area. And then I'll pick that point up in relation to just getting that aspect. But one of the points, because I just wanted to underscore this, onto the evidence of the first respondent, Mr. Arturo Matus. There are photographs that are there. So this issue of the quality of that land and the fact that that was swamp land, the whole transcript is replete with that. Even the title document that he has, which he attaches onto it, uses the word swamp land in reference to a description of the land. So that what we would say in respect of the evidence, and I would get the reference in relation to the specific aspect of this, that the Commissioner Viejos would have spoken about, is that the quality of the land would have been that it was accreted land, it was water, it was swamp. And that was not something that would have been disputed by the appellant here and by the respondent government for the Registrar of Lands. They conceded that fact. And so how this entire area of land was developed harkens to the quality of the land, and it surely suggests that the first respondent's position is the correct position, that this was really wetlands. And in the description, the legal description of the title, it makes reference to that being the quality of the land. If I may just 1 second, just try to localize that reference.
If I may be of assistance, page 373 of the record.
373.
Thank you. Yes, Your Honors, so that the position on this point in relation to the first respondent is that there is no evidence that this 44 feet would have been land, that this entire 44 feet would have been filled up or it would have been built up on land. And the evidence that came out at trial would have been the contrary, because all the witnesses, Mr. Viejos for the government, Mr. Quinto for the appellant, and Mr. Matus for the first respondent, would have given a description as it relates to how these lands would have developed and how the land would have built as being accreted land and it was swamp land. And that reference from the Commissioner of Lands is actually important because of just what the lands of Belize City and the entire country is. It's low-lying areas. And in circumstances, the 44 feet is sometimes given in areas, or the 66 feet, it can be as much as 66 feet, is sometimes given where the edge of that 66 feet is actually in the middle of the river. So that what our position is that that squares with the evidence that came out at trial when all of the parties discuss the quality of this land. And I think that that is where the reference came in the Court of Appeal. This would be at paragraph 16, where they would have said that it's uncontradicted evidence. There's no evidence that really was led that said that this would have been solid land in terms of what it was built up upon land. Everybody, including the trial court, recognized that this was swamp land.
Yeah, but Mr. Bradley, yes. Client's witness statement makes it clear. And as I said, when there are admissions or concessions or particular statements made which the other side can benefit from, when such statements are made in the opponent's witness statement, then a court is very much entitled to latch on to those statements and to give them particular weight. And as I recall, your client's witness statement says that the reserve, whether it's 30 feet, 20 feet, 40 feet, 60 feet, that reserve, which everybody calls it, represented the high and low water mark. Now, I have no doubt that at certain times of the day, depending on the height of the tide, some of that reserve is in water. At certain times of the day, maybe all the 40 feet or most of it would be not water. And if it isn't water, whether you want to call it swamp or land, but it was not the river. And so I don't know that we are getting very far in, having a discussion on whether it was 40 feet or 20 feet or 30 feet. The clear statement of your client is that how much of a feet it was, it basically represented the high water mark and the low water mark. So I think we should move on from that. And this is not to deny the fact that he also says, because we can't, take one without the other, except if cross-examination sort of intervenes. But he also says that at high tide, when it exceeds, at high tide, it could exceed the high sort of the edge of the reserve and flow into his 4105.
Yes, Mr. President. And so that would be your position. The evidence is what it is, and the evidence is there, and we would move on. We would say that the evidence is clear in relation to what he's talking about, and that it meets the threshold that the water comes in regular contact with 4105 sufficient enough to create riparian rights. And that would be our position in relation to the evidentiary aspect of the case.
Yes.
Mr. Bradley, just to confirm.
Go ahead.
Sorry.
Mm-hmm.
Mr. Bradley, just to confirm, you would have indicated before that you do not consider the test to be continuous contact. I think I remember you saying that. Can you let me give you the opportunity then to just lay out clearly what is the applicable legal test that you are asserting is relevant for the creation of riparian rights in these circumstances. Can you just clarify that for us, please?
So what we would say, and thank you for the question, Madam Justice, what we would say is that the test is that it has to come in regular contact with the water, so that we don't say that regular contact has to be daily contact. So that there are authorities where for the greater part of a year, for example, the embankment would have been left bare. But for the other part of the year, it would have been covered, so that this would be a matter of fact to be determined by the trial court in relation to the distance of the land, the quality of the land, in what time periods would it come in contact with the water. And so what we would say is that there would have been regular contact. There's some sort of relationship with the water, use, access, and contact. But this notion, and my learned friend, in terms of her submissions, makes mention of it. It's from Halsbury's. The Court of Appeal mentions that, but that's only one authority that they cite in relation to the cases that we put forward before the Court of Appeal for meeting of this particular test. This is starting at paragraph 12 of our submissions, where we go through each of the authorities. I believe it's 8 authorities, and we talk about what is in between the riparian right the riparian landowner and the water. And in all of those cases, there would have been a reserve. In one case, there would have been a train track that would have run between it. There would have been embankments. There would have been a fence. There would have been a walkway. So that there are many different things that go between that, but it does not interfere or negative the riparian right owner. We would also say in relation to the authorities, it's mentioned in the Halsberries that we cite, but it's also mentioned, I believe it's in the fishmonger case, that when you have accreted land, so that if I had land which we submit was the quality of this land, that this land, all of it was just island or swamp or underwater, and the land silted up over a period of time. And if you have accretion, that itself does not sever the riparian right entitlement to access to the water. So that in terms of paragraph 12, going onwards, we cite what we think is the relevant principle, that there has to be some contact with the water. In terms of what contact is, that would be a matter of fact in the particular circumstances, and how the land developed also. If it's accreted land, that's part of the factual matrix. And all of those are within this case. In terms of all of the witnesses, consistent explanation as it relates to how this property, how all of these parcels of land developed.
Mr. Bradley, just a couple more questions, please.
Yes, yes, Madam Justice.
You've indicated that based on the authorities you've cited, the regular legal test does not require daily contact. And you've said regular contact is to be understood based on the circumstances of the case. The authorities that you would have cited, did those authorities involve the kind of circumstances we're dealing with here, where there is some kind of land intervening between the water and the owner's property?
All of the cases deal with that. So all of the cases deal with the issue of there's something in between the owner's property and the water. And so some of the cases deal with that as being a reserve and embankment. Some of the cases actually deal with it as being like a built-up thing, like a train track or a walkway or something that's physically constructed by public authorities. But all of the cases that we refer to, both in the Court of Appeal and that we rely on here, deals with cases where there's some interruption. There's not a continuous contact between the riparian landowner and the water.
Okay, and my final question is, for now anyway, is where the Court of Appeals judgment is concerned, because we understand that the trial judge would not have found it's a very thin statement, but essentially the trial judge would not have found that that parcel 4105 abutted the Belize River. You are clearly relying on the Court of Appeals judgment. Can you point us to how you believe the Court of Appeals judgment demonstrates satisfaction of the test that you're saying is applicable here?
Madam Justice, one of the things that I just wanted to, before I just get to that point, and sorry, because this came from you, Madam Justice, and not to piggyback off that argument, but Madam Justice had made the point in relation to even if it abutted, that the High Court mentioned that even if it abutted, and so that we would hang on to some kind of fig leaf that the High Court would have been prepared to concede that, but they made the determination on a legal point. They made it on a legal question that because there was this piece of land in between the water and the first respondent's land that severed the riparian rights. What we would say in relation to the Court of Appeals decision is that the Court of Appeal, from a factual standpoint, was very clear that the uncontradicted evidence was that for a continuous period of time, the Court of Appeal felt that for a continuous period of time, the evidence was uncontradicted that the waters of the Belize River touched 40 105 for purposes sufficient to create riparian rights. So in relation to the issue of the high water mark or the low water mark, there's a lot of evidence in relation to the water, the buildup of the land, and I believe that when the cases are reviewed in terms of the Court of Appeal, the Court of Appeal felt satisfied that all the evidence led to the natural conclusion that this land would have touched the river's edge sufficient enough and continuous enough to create factually a entitlement for riparian rights.
Okay. Mr. Bradley, could you just assist me by pointing to that place in the Court of Appeal judgment where they actually speak to continuous and so on contact? Yes, because I have been looking for it. It may just be that my lighting is not good today, but I'm sure you will see it. You will find it, counsel, because you know your case. Thank you.
Thank you for that question. At paragraph 12, the Court of Appeal starts to talk about the legal authorities that were raised in relation to the case itself.
But Mr.
At
Bradley,
paragraph 11, sorry.
Oh, please proceed, please. I'll come back in if necessary.
I just wanted to say that the discussion on this begins at paragraph 11 on this issue of the reserve. And what we feel is that the High Court, the decision in the High Court was determined based on this presence of this thin slither of land. And so that in the Court of Appeal said that, no, that piece of land does not sever a riparian right owner. It's entitlement to riparian rights. And so at paragraph 11, they make the point that the presence of this land does not interfere with that rights. And then they go through the various authorities. The first one is the Halsberries. I just wanted to invite the panel to consider that the last paragraph of that passage, they talk about accreted land, so that we would submit with respect, and the authorities we submit make this point, that we could get to the finish line in multiple ways. And this issue, of course, in the ordinary course of time, your land would be right next to the water, but there are different ways that a person can claim riparian rights. And we would say that the issue of accreted land certainly would have been something which would have been in the contemplation of the Court of Appeal's mind, because the passage that they refer to in Halsbury, the last paragraph, mentions that as being part of the test itself. So that,
yeah, but there's something I wanted to clear up here, yes, Mr. Bradley.
Yes, sir.
Your client acquired 4105 in 2003, is that correct?
He would have acquired it prior to that. His witness statement talks about him. He would have gotten title in 2003.
He got title in 2003.
So he traced it. Sorry.
But at the time that he acquired title to it, whether we want to call it a 40-foot piece of land or a reserve or whatever, that was already accreted. Is that correct?
We would say no, because we would say that part of that 44 feet was in fact water, so that would not have been accreted land at that particular time. So that when the appellant, when the first respondent acquired this land, they note on the type, the description, because they're supposed to do a description of the land, it lists this as swamp land, so that we would submit that in—
It listed what? The portion 4105 or the portion which we have been calling the reserve?
We would submit that a portion of 4105 and the reserve would have been water. So that he talks in his witness statement about him filling this area, him building his house on this area, so that the witness statement is rather detailed in relation to how he came. I believe, I'm looking at it very quickly, I believe he said that he came into a lease interest in 1997. He would have then continued works in terms of filling up this land, and then he applied for the title, and the title was eventually issued in 2005. So he traces and places his ownership of the land, including he makes reference to the description of the land as swampland. So that what our position would be...
When was this survey done? Was there a survey done that delineated his boundaries and also that showed the area of what we've been calling the reserve?
Yes. So there is a survey.
It must have been done at or before the time he acquired 4105 by title. Is that correct?
That is correct. So that the surveyor is done. I would just quote their witness statement, if I may, just very quickly. So he says the survey was done in 2002 by C.B. Samuels.
Okay.
And then I would just invite your honors, if your honors choose to do so, to consider AM4, which is the survey plan, so that the survey plan would have shown that his surveyor put that in there, and he explains why he put that in there for a buffer zone to protect what would have been 4405.
Who he? The surveyor?
The surveyor put that. Sorry.
No, go ahead.
The surveyor would have done it so that in terms of just the acquisition of the land, he would have said that he acquired an interest in 1997. When he's applying for his title, there has to be a survey of this property done. He speaks about the survey being done in 2002 by C.B. Samuels, and his surveyor would have put that reserve in there to compensate for the flow of his land. If the reserve would have been in his land, he would have naturally had less land. So he put the survey as a buffer zone. So the survey, and this also came up in the trial court and in the Court of Appeal in terms of the evidence of Mr. Vallejos in relation to whether or not that's a government survey or who put that survey in there. But the survey was certainly recognized by the government as being something that was a protection for his property.
Mr. So I'm asking these questions in light of the end of the quotation just preceding paragraph 13 of the Court of Appeals judgment, because my understanding of that paragraph, if in the course of time the water recedes from the riparian land owing to natural silting up or artificial reclamation, the riparian owner may exercise his right of access over the accreted or reclaimed land. That in this particular case, the boundaries were already fixed, and in his statement, they were fixed so as to take account of the high water mark, the normal high water mark of the Belize River coming in the direction of his land. But anyhow, you proceed.
That is correct. But the point, and I really want to just make this point very quickly, but so the surveyor would have done this this survey, and the surveyor put in these dimensions in relation to what would have been approved by the government in relation to the creation of this particular parcel of property. The reserve would have been put in there by him, but we would submit that in terms of, and perhaps maybe I get in trouble for this argument, but we would submit that what is important is factually what is on the ground. What is factually on the ground is that this is swamp. And this is all water. And this would have been land that would have been filled up by all of the parties over a period of time, so that Mr. Quinto talked about his land, which would have been adjacent into the Caribbean Sea, which he would have built up, which was originally an island, and it silted up over a period of time. So that certainly is the context in relation to which all of these issues of riparian ownership comes as a result. And so, yes, there is the survey, and yes, there is the putting in of that reserve, and then the titling of that as land. But according to the National Lands Act, land includes water as well. And what we would say in relation to that is that that would have bared little resemblance to the actual factual situation on the ground that this would have been a piece of land that all the parties would have had to develop over the course of several years. And that evidence certainly came up, and that was a concession that my learned friend made in her submissions, where she repeatedly, my learned friend repeatedly used the word island, silting up, accretion, swampland, so that factually this would have been developing as organic land. And so one of the things that I would say here is that surely in relation to the points and in relation to the time period, when did things come about? What is the high water mark or low water mark in terms of all of those? Those would have been points that that would have been raised or should have been raised in cross-examination, but for purposes of making out the claim and the pleadings point, it was sufficient enough to create in terms of what was explained as the factual quality of the land by the first respondent himself and by all other witnesses, and which would not have been challenged by any of the other defendants. The factual quality of the land is that this land needed to be filled up because it was water.
Yes, Mr. Bradley.
Forgive.
Sorry, there's one thing which has been sort of intriguing me for some while now. Is there any relationship between the creation of the reserve and the Section 28 of the National Lands Act?
Forgive, Mr. Justice, one second. In relation to the creation of the high water mark and the low water mark, so what we would say in relation to this is that Section 28 makes a statement that the boundary should have been taken as a certain point. So the boundary of the land should have been taken. What we submit is that that's an entitlement, so that when a person does their survey, or when a person sets out their survey, the boundaries of the survey would be determined at a certain respect in relation to what the law prescribes. Section 28 certainly provides a prescription in relation to determining what the boundary markers would have been as an entitlement. And what we say in relation to this, a survey would have been done, and the survey would have placed a reserve in the property, and the survey would have placed that reserve so that the part of that survey would have been in the water, so that he actually doesn't lose the quality of certain parts of the land. So our position in respect to Section 28 is that Section 28 is an entitlement. So when we determine the boundaries of a particular land, when you make considerations, the boundaries can be considered in relation to what Section 28 says, but that doesn't speak to putting in a reserve and having the reserve be as the buffer zone. The qualities of land in this particular area would have been substantially affected by the water.
Thank you.
Mr. Bradley, just to briefly return to the questions that I had asked, it's quite important. The Court of Appeal, as you rightfully said, had addressed in its judgment largely the question of whether the mere existence of a reserve or this intervening plot of strip of land would have negated the existence of riparian rights, and they clearly concluded that it would not, that riparian rights could arise in the circumstances. You have indicated that you think the applicable test in the circumstances, meaning where there is this intervening strip of land, is that there is still some kind of regular contact with the water. And you said it doesn't need to be daily. What I would really appreciate is if you could point to the part of the Court of Appeal's judgment that you think sets out what the relevant test for creation of riparian rights in these circumstances would be, and what the Court of Appeal actually used as the evidence of satisfaction of that test. I don't know if I'm being clear.
Madam Justice, you're being very clear. You're being very clear. So, Madam Justice, in response to your question, I would just cite, because the case is what it is, I would just cite that even in paragraph 14 of the decision of the Court of Appeal, where they quote the relevant passage from the English Court of Appeal in Port of London Authority and Caney Islands, where it actually says it is necessary for the existence of a riparian right that the land should be in contact with the flow of the stream, and he adds that lateral contact is as good as vertical.
You may get there eventually, but Council, would paragraph 19 be of assistance to you?
Thank you. Yes, and thank you for the assistance, so that we would submit in terms of the authorities, they cite the authorities, and at paragraph 19, they make this sort of conclusion in relation to the point that the riparian rights can exist over land not owned. And the test, as we say, comes from the authorities, as was cited by the Court of Appeal, is in terms of dealing with this contact. What is meant by contact? One of the things that I will submit is that perhaps this is language that is inelegant, but it's a qualitative test. And so surely if your land has no contact with the water, then that would be something that would not create riparian rights. But I believe that the authorities, and we cite all of the cases, both in the Court of Appeal and here, where they give specific examples in relation to what interferes with the land, the authorities use a more qualitative test in relation to, okay, what's your relationship with the land? When we say contact, what is the contact that you're seeing that you have with the land? And there is clear evidence, both from the evidence of the first respondent and all the other witnesses in this particular case, as it relates to what the contact of 4105 would have been with the water, including paragraph 6 of the affidavit of the respondent, which we submit was not seriously challenged. And so what we say is that there would be a nexus here, that the authorities say that you have to have continuous contact with the water. And in terms of continuous, it is a relational thing. It is qualitatively determined based on the facts. And we would put the facts on this, and the Court of Appeal would have been satisfied that the uncontroverted evidence would have been that qualitatively this land came in regular contact with the water, sufficient enough to create riparian rights. If
so,
Madam
Council, not to interrupt you, so that essentially the word abut does not mean contiguous.
That is correct.
That is essential.
So that what we're saying is that the word, in terms of the authorities, they use abut, and I think that this is what the High Court sort of felt, that the land does not abut the water. And what we said in the High Court and in the Court of Appeal, and what we're arguing in the Apex Court here, is that there's no requirement for the land to abut the water. There is a requirement for it to have regular contact with the water. And regular contact is a qualitative test. And the court would look at the factual circumstances. And in this particular case, the Court of Appeal held that there is sufficient contact with the water on 4405 for purposes of establishing riparian rights in these circumstances.
I get the impression, Mr. Bradley, that the Court of Appeal's judgment and the latter part of paragraph 18 and paragraph 19 suggests to me that their reasoning is that sometimes this reserve is inundated with water. Since 4105 abuts the reserve, therefore 4105 abuts the water, abuts the river. I think they're very clear. I think we have a problem though. Ms. Tucker and council apparently have had a blackout.
Oh dear.
I don't know. We have been seeing them, but we've been seeing them in darkness. Are you hearing us, Ms. Tucker?
Thumbs up.
Okay, so then we can still see you, albeit it's a little dark. So we could continue. Yes. So my impression, reading paragraphs 18 and 19.
Your Honor, I'm sorry to interrupt.
My impression is that the Court of Appeal resolved this question by saying, look, you abut a reserve. That reserve is inundated with water at least sometimes, and therefore you must enjoy riparian rights because you abut that reserve. Before you answer that, I think Ms. Tucker wants to say something. Ms. Tucker? Can you, yes. You're able to hear us, but
she's not hearing you. So I think what she needs is 10 minutes for them to move from this location in Belize to another one. So they may need us to stand the matter down for about 10 minutes, President. Ms. Tucker, is that correct? Raise of hands. Thank you so much. Thank you, President and judges.
We'll take a short adjournment until it will be 13:45 in Trinidad and Tobago, which will be 11:45 in Belize.
Thank you, Your Honor, for the opportunity to relocate.
Yes, you're welcome, Mr. Kang. Yes, Mr. Bradley. Are we seeing Mr. Bradley? Yes.
Yes, Mr. President.
Yes. What else you like to tell us?
Yes, Mr. President, just before we concluded, you had indicated a question in relation to paragraph 17 and 18 that the Court of Appeal had seemingly concluded that water would have come onto the reserve, and by virtue of water coming onto the reserve, and because the reserve abutted the claimant's land, that was sufficient in law to create riparian rights.
That's correct.
2 points that we would want to make in relation to that. And we invite your honors just to consider in the authorities that we cite, and that starts at paragraph 12, but including paragraph 17, where we cite the case of North Shore Railroad Company and Appellant and others, which was made reference in Belize to the Belize case of National Fishermen Producers Cooperative Society and Brown Sugar Marketplace Limited. And all of the cases give illustrations and examples. We pull out the factual parts of the case that establish what we say is the applicable law. And in that particular case, the defendant had built a railway along the riverbank, and it had interrupted this was actually built on a portion of land admittedly not owned by the riparian owner. And in that particular case, the court felt that it was sufficient enough that it did not sever the riparian right owner. There was still access or use of the water. So that in response to the question, we want to say two things. That number one, the presence of the reserve, even if your honors were to find that water did not, which we do, it is not our position, even if your honors would find that water did not go on to 4106, that is sufficient to create riparian rights. But our position is that the evidence of the first respondent is that this reserve was actually something that changed its quality over the course of the day so that water would flow through the reserve onto the claimant's parcel of land. But we would invite the court, as I believe the Court of Appeal did in relation to going through the authorities, looking at the examples in relation to the authorities, looking at what the first respondent was saying, that land could be in the middle and that land could interrupt your access to the water so that you have no longer direct access to the water, but that still does not sever the riparian right owner. But in our position, the evidence that came out from this particular case is that, as is paragraph 6 of the statement in the witness statement of the first respondent, which we would submit it to the court for consideration, that his evidence is that the waters actually went into 4105.
Okay, so you're casting a very wide net, Mr. Bradley. Would that be fair to say?
Yes, Mr. President, we're casting a very, but we would say, Your Honor, and the reason why, and then this would be just a point here, because I'm noticing the time in relation to our time, so that we would say, though, that, and I believe the Court of Appeal appreciated this, and the authorities and our understanding of the law is that one can get to the finish line in multiple ways. The usual way is regular, direct contact with water. The interruption of access to this water by a reserve doesn't sever the riparian right owner. It is sufficient to establish riparian rights if there is regular contact with the water. And in relation to regular, that would be something that would be qualitatively determined, as a matter of fact, based on the legal tests and based on what is factually the case at bar. And in our position, this case, the evidence of the first respondent, which was not challenged, was that the waters do come on to 4105.
And the accretion, the nature of the land, as you had said earlier.
And the accretion.
Does that net extend to the question of easements as well, or you're so embarrassed by riches that there's no need to take in easements?
We did, but this was one of the things, perhaps it is just in relation to our particular position. My learned friend for the appellant was correct that we cast a wide net in relation to the framing of the claim. The Court of Appeal, of course, we kind of directed the arguments and focused the arguments more narrowly because we looked at the High Court decision and what we conceivably thought that we could prevail on. But this issue of necessity would be something that it was mentioned in the Court of Appeals decision.
Yes,
it was a point that was mentioned by the Commissioner of Lands that all land has to have some sort of out access. And this river would have been the out access for the first respondent. This would have been the out access because all the other parcels of land would have been surrounded. The Court of Appeal asked in relation to the other parcels of land that he would have owned and whether or not he would have had access to other parcels of land. I just wanted to make this point very clear that there's evidence or there's a statement that's made by my learned friend in relation to the situation of where his house is. He talks about that in the affidavit as to where in his witness statement as to where his house is and what are on these parcels. And I would, of course, commit that to the consideration of the Honorable Caribbean Court of Justice.
So that point you just made about the easement, how do you reconcile that with the statutory requirement for occupation for 20 years? I think there is a requirement in the Land Registered Land Act that to claim an easement, there should be use enjoyment for 20 years.
Yes, this is one of the reasons why, again, and this would just be respectfully in relation to this concept of an easement by necessity, so that there is, of course, easements that are created by long possession. There is also the concept of an easement by necessity, that all lands have to have an exit way. It has to have some sort of exit way by way of some public thoroughfare or navigable access, including a waterway. And so this would have been the only access way, so that surely he would not have had this settled interest. Now he perhaps does after the course of a 20-year period. But at the time when this case would have been argued in 2016 or 2017, I believe, that time period would not have elapsed. But our argument was an easement by necessity, and this would have been accepted by the Registrar of Lands, that all lands have to have some sort of public outlet. And this would have been the public outlet for that. With respect.
Thank you. Thank you very much.
I just want to follow up on that point. Parcel 5031, that's the parcel which Ms. Barrow shaded pink. Is that correct? That's the reserve that was sold.
The reserve is only a portion of that.
It's included a portion of that. Right. Okay. Yes. But parcel 5031 has direct access, well, it abuts the river. Is that correct?
5031 abuts the river, that is correct.
Parcel 164, does that have any access to a road or to the river?
I do not know. And one of the things that I would say, my learned friend has mentioned the history of this particular parcel of land. And I just wanted to put this argument there. If my learned friend is claiming in relation to 164, and you used to go through what was then a piece of land, and then it was created into my client's parcel of land, there's no claim that they brought in relation to the court. So one injustice or one error doesn't preclude another person from advancing another error. So that our client brought his claim, our client is saying that, well, this was my only access way and you took away my only access way. If 164, that issue occurred with 164, then it would be for them to have raised that issue at the appropriate time and to marshal a claim for that. I certainly do not know in relation to whether or not 164 has some sort of public access way. I only know.
Okay, fair enough. I'm interested in the situation on the ground currently. Is it that the owners of 5031 have barred you from accessing what used to be the reserve? So that
is correct.
You can no longer. So how do you get to your boats on your pier, the pier that you built?
So he no longer has access to that. So that so part of the claim was an injunction. So the witness statement of Mr. Arturo Matus, the first respondent, exhibits photographs. He talks about a fence that was erected by the appellant in relation to interrupting this. This was a very large fence. There are photographs of the fence, and so that he's saying that he no longer has access to that. So from when he had written to the registrar, and the registrar had wrote back to say, surrender your title, we want to do a rectification by consent. From that period of time to now, he no longer has access to the waterways of the Belize River.
Okay, and what would be sufficient to get him access? Would it be for the owners of 5031 to allow him to pass through that a part of the fence to get to the pier that he built?
So what we would say is that the Court of Appeal correctly outlined what would have been the appropriate remedies, which would have been part of what is claimed on the fixed date claim form of the first respondent, which is that they claim the permanent injunction, they claim a rectification of title pursuant to Section 143 of the Registered Land Act, that in line with the letter, which is paragraph 3 of the judgment of the Court of Appeal set out the full letter from the registrar, where the registrar was trying to do a rectification by consent. So he asked New Deal Limited, the appellant herein, to surrender your title and let's voluntarily do a rectification, because we never intended to give you that thin piece of land between 4105 and the Belize River. You were only supposed to get the remaining area. They said no, and then so we commenced a claim, including for an order of rectification by the court pursuant to 143 of the Registered Land Act. And,
okay, fine.
Forgive.
Is it that since the discussions that broke down and the court proceedings and so on, is it still possible for that kind of order to be made, that your client be allowed to have some right of passage to get to the pier that he had built?
We would say yes, so that we would say that the Court of Appeal gave the order in relation to the rectification. That is a remedy that's prescribed by the Registered Land Act. We certainly made out that, and we pled that as a remedy in the claim form, that we were asking for that together with the injunction, and the Court of Appeal granted that. So this would not have been something where a long passage of time would have occurred. I mean, it is a long period of time, but it's just because we are going through the various courts, the High Court, the Court of Appeal now.
I just wanted to know whether any kind of physical structures or so had been.
There is a fence.
There's just a fence. What kind of fence?
It's a cement fence. It's a very high fence. And then there is reference in relation to the affidavit of the first respondent that speaks about the fence. And we attach photographs of the fence, both an aerial photograph and a physical photograph of the wall. One of the things that I just would want to add here also, and I would invite the court forgive because it's just in terms of just a lot, but there is a lot of evidence, including aerial photographs of this area, where the river is, and the photographs were very, very detailed, and the High Court found it very, very helpful in terms of looking at that. There are photographs that the first respondent attaches onto his claim form that shows you that there is water in the area that's called the reserve. Like he physically takes a picture of the land, and it shows you. It shows.
Mr. Bradley.
Sorry,
yeah.
Yes.
You don't need to all of that again.
Sorry.
But sorry.
Yeah, go ahead, Justice Anderson.
This is a critical point, because the Court of Appeal basically is saying that what we are calling the reserve ought now to go to your client. Is that basically?
No, the Court of Appeal is saying that what we're calling the reserve is what our client always had access and riparian rights through. So that riparian rights, according to the brown sugar case in Belize, is recognized as a constitutional right. So we're not saying that we don't say that we own the reserve, but we say that the reserve is something that we always had riparian rights over and through, and that riparian right should be protected by way of an injunction, and that access way should not be given or sold to somebody else. So the claim as framed is that the creation of parcel 5031 interfered with our client's riparian rights because he always used to access the Belize River through that area of land, that thin
But
area.
he considered it as his own.
He considered it as his own.
But that's another story.
Yes.
Yes.
No. But so there's a rectification then of the title that is required.
There is, and this was
to
pleaded.
basically cut off what we're calling the reserve from the appellant's title. Is that so?
That is correct. So that the
Right.
Court of Appeal
No, but
would have
that
given
requires sorry, Counsel, but that requires certain legal tests to be satisfied.
That is correct. So that a rectification in law, according to Section 143, could be done by fraud or mistake.
Yes.
And we ground our claim for rectification. We don't say that there's any fraud here, and we would never impute that on and that was never an allegation, but we do say that it is grounded by way of mistake, so that the sections in relation to, and I probably would be clearer here, the section for the test in relation to a rectification is set out in Section 143 of the Registered Land Act, that a rectification could be ordered by the court if in circumstances of fraud or mistake. And we would say that the issuance of title to include that area of land was clearly done by mistake because the registrar of land tried to take it back. The commissioner
said something different, did he not?
The commissioner of land set out in the letter that
yes,
they sent the letter by mistake. I mean, of course, if I were to be caught in a mistake, clearly, perhaps, for whatever reason, I'm not saying anything in relation to the registrar. My learned friend for the government would speak for them. But if I am caught in a mistake, clearly I would try to say that, well, you know what, the letter was an error. So the issue is that the letter was an error, or the issuance of title for 5031 was an error. What's the mistake? And we are saying that 5031, to include that reserve area in front of the appellant's land, that was the mistake. And that was when they sought to correct it by issuing this letter. I'm following you,
Mr. Bradley, and I know time is going. So I just wanted to ask you, is there a way of getting what your client wants or your client thinks is his deserts, other than the rectification of the title of the appellant?
What we would say with respect is that's what he pled in the case. That's what we marshaled in the High Court. In the Court of Appeal, we succeeded on that. And we would say with respect before this Honorable Caribbean Court of Justice that that would be the remedy that he seeks. He seeks access to the Belize River through this reserve, which he always enjoyed from 2000 to 2014. He enjoyed that for a period of almost 15 years.
Mr. Bradley, there are a number of different little nuances.
Of course.
There is access for him to go from 4105 to the pair. There is also a claim that he could pretty much disregard somebody else's ownership of 5031 because he has riparian rights over it, and he could pretty much do what he likes on it, or at least disregard the fact that it is the property of another landowner. The point is do you accept that there is a middle ground where he has to, and this is hypothetically speaking, we haven't decided the case, he must recognize the ownership of that parcel of land by someone else, but that owner must provide him with access to get to the pair.
Mr. President, this is the million-dollar question. It comes at the tail end of my argument. I will answer very quickly. This is a constitutional aspect of the claim. The first respondent marshaled this in the High Court on a constitutional protection that when they Commissioner of Lands created Parcel 5031, they interfered with the first respondent's constitutional right to property in relation to riparian rights. And there are authorities that we cite which makes that clear that riparian rights are constitutionally protected rights. So what our claim was in the High Court and in the Court of Appeal was that the creation of 5031 to include that sliver of right fundamentally violated the first respondent's constitutionally protected riparian rights.
My point is, Mr. Bradley, that hypothetically speaking, it is possible to deny that claim, but still require that the owner of 5031, because all land in Belize must, as you say, not imprison the owner of the land, but have some outlet, exit, that the owner of 5031 must provide that outlet, that exit, that access for the owner of 4105 to get to the river. They're two different things. At least I see them as two different things.
I agree with that. But what I would submit with respect, Mr. President, is that a person's access, to my mind, it is, and this is with the greatest of respect, and this is just my humble view, to my mind, it undermines a person's constitutionally protected right to say that I have to pass through somebody else's property. The government owes me.
It's called an easement.
Sorry?
The law provides for it, and it's called an easement.
Yes, with respect. So with respect to an easement can be created by consent, it could be created by agreement, it could be created by the 20-year long possession. What we're saying is that he always had access through this government property. And to say now that when he asserts a constitutionally protected right that is recognized in terms of riparian rights as constitutionally protected, that we would then indicate that, okay, well, have rights to somebody else's property. In my mind, with respect, that does not validate the claim that he actually made, the constitutional claim that he actually made, that from the very beginning, the registrar conceded that this was a mistake, that we never intended, and that's what the letter shows, evidentiary, that we never intended that he get access to this thin piece of land. He could get the remainder of 5031, which is a huge area of land, which has a lot of waterfront, but he was never intended to get this small area of land that takes away our clients' access, only access to the waterfront. And so with respect, yes, there could be a middle ground, but we would humbly not say that that would validate the fullness of the claim, including the constitutionally protected aspect of the claim that the that the first respondent marshaled before the High Court, and he was successful on in the Court of Appeal.
Okay.
With respect.
Okay, is that it?
That would be the submissions for the first respondent.
Yes, thank you. Ms. Barrow, I assume
sorry. The second and third respondents.
The second and third respondents?
Yes.
Are you making submissions?
Much obliged, Mr. Honorable President and Your Honors. John Graham for the second and third respondents. If it so pleases the court, we rely on our written submissions filed herein, and we would like to start by addressing the issue of two theories as it relates to riparian rights. That is, one, land that directly abuts water and is directly in contact with water. And secondly, land that is, for a great part of every day, in the ordinary course of nature, water contacts that property. We take the view that in the facts of the instant circumstances, the land that is truly the riparian land is Parcel 5031, as Parcel 4105. First, it does not abut water. Secondly, for the great part of every day in the ordinary course of nature, water does not contact that land. And the evidence of the first respondent is that at high tides, the Belize River would come onto the fence that was constructed by the Appellant and sometimes go beyond that fence up to 10 feet onto Parcel 4105. Now, what is not before the court in evidence is the frequency in these occurrences, Your Honors. How often does this high tide where the water comes all the way onto 4105 happens? So that is the first submission that we would like to make, Your Honor. Secondly, the evidence of the first respondent as well is that a dock was built, which at trial, it was confirmed that that dock was built without the relevant licenses to do so. As to build a dock, the area in which the dock is built protruded into the water body is considered the seabed or the riverbed in this instance, which the state owns, and license from the state is required to do that. But nonetheless, the respondent has given evidence that this dock was built and he would traverse the reserve to moor boats and swim, etc. Your Honors, we suggest that where we put forward in submission that this provides a highly probable inference that this area, the reserved area, was not frequently covered by water, and therefore the first respondent could have traversed this area freely. And that, we say, is a reason why 4105 could not be the riparian land, but 5031 is the riparian land. And we say 5031 is owned by the government of Belize. It's in its entirety, and it was land that, within the discretion of the minister with responsibility for lands, could have disposed of in or on terms and conditions as he deems fit, as the National Lands Act provides. Of importance as well, Your Honors, is where this land is located geographically in Belize City. There is no law that compels the government to establish a buffer or embankment or beach between a parcel of land and a river. The laws that provide for that reserve are in relation to rural lands, and the National Lands Act subsidiary laws provides for that at section 33, subsection 3. And therefore, on that premise, we submit that in creating Parcel 5031, which northern boundaries directly touches the Belize River, was indeed lawful, as there was no need for a reserve to be created there for the low water and high water mark. At trial, the former commissioner was asked whether, when a reserve is noted or labeled on a survey plan, whether the purpose for that is to note the high water and low water marks. And he noted that that is one of the reasons. He indicated to the court that other reasons may be that it is government land, which the government has not yet disposed. And when asked by the trial judge whether it was a government reserve, the commissioner confirmed it was a government reserve. And so, in assisting this honorable court in adjudicating the issues before it, we put the argument forward that 5031 was government land, and the first respondent did not own or had any entitlement or legitimate expectation to have a right to that 520 square meters of land, which was directly in front of parcel 4105. To address the letter from the ministry frontally, it has been the evidence of the Commissioner of Lands for the former commissioner, that letter was issued erroneously and prematurely. That has been his position in his affidavit evidence and his position at trial. And it has been the position of the government defendants at first instance and at the Court of Appeal. And so we humbly ask that this Honorable Court give weight to that position, that the letter was erroneously issued. And of one important element in that letter, why we say it was erroneously issued, was the clear declaration in the letter to say that 520 square meters of land belonged to Arturo Matus, Your Honors, without any title, without any survey, which directly indicated that that area was of an interest, whether in law or equity, for Mr. Matus. It would have been erroneous at that stage for anyone within the ministry to declare that that portion of land belonged to Mr. Matus. And so the commissioner, in his experience and knowledge of what was the circumstances at the time, made it clear that that letter was erroneous and that the land in its entirety was national land and was subject to dispossession by the government once the proper procedures were carried out.
Anything further?
Favor indulgence, Your Honor. Unless Your Honor have any questions for the second and third respondents.
Yeah, I have one question.
Yes, Mr. President.
If Mr. Matus chooses tomorrow to sell parcel 4105 to you, how would you gain access to it?
Not eerily.
Your Honor, there is also parcel 4106, which is owned by Mr. Matus. And so if Mr. Matus approaches me in my personal capacity to purchase 4105, I would try to negotiate with him for an easement to be established between 4106 and 4105, as 4106, Your Honor, in my humble opinion, is a dominant parcel that serves 4105.
Yeah, if I may, as we were discussing with Mr. Bradley not long ago, I think there are issues to do with the challenge facing the court for going through with the rectification of the title. Clearly, substantial challenges. But would you agree with Mr. Bradley that if there were riparian rights to be found, and these were considered to be constitutional rights, then those difficulties would fall off, that the court could, as indeed the Court of Appeal did, order the rectification of the title? Would you agree to that?
If there is indeed riparian rights, the court could make such an order on the basis that the creation of the parcel was a mistake. But factually and based on the learning, respectfully, Your Honor, 4105 is not a riparian land, as the test to be satisfied to be a riparian land.
No. Yes, we understand. Sorry, I don't want to interrupt, but I was just trying to get that very clear. And then the middle path would be if it was held no riparian rights, but there is a right to an easement. That would not necessarily require the rectification of the title. That would require access to the river, I presume through a defined delineated path, right?
You're indeed correct, Your Honor.
Okay, I've got that clear. Thank you.
Much obliged.
Yes, well, thank you for your submissions, Mr. Graham. Ms. Barrow?
Yes,
Much
yes,
obliged.
obliged, Mr. President. I wanted to take the opportunity to get clear high tide. I found the reference that caused me great confusion, and I think it will help us all to understand what is a reference to tide. And if I may share on screen the portion of the Halsbury that I will happily provide to the court after. And my learned Judge Burgess was half right in that the high water mark does indeed represent the line of high, the medium line of high tide. Spot on. But this is the part that created confusion, and I have gotten it clear now. Between the spring tides and the neap tides, those tides do not occur daily. They occur monthly in regards to the moon. So a spring tide is a tide occurring shortly after a new and full moon. That is when it is at its highest level. And a neap tide is a tide occurring shortly after the first and third quarters of the moon. That is when it is at its lowest. So if the average takes place throughout the course of the month, it is not a daily occurrence.
But it's a regular occurrence.
It is a regular occurrence, absolutely, undoubtedly, indisputably. Which brings me to the submission made by my friend as to a qualitative test. It sounds sexy. It does not exist in law. It does not exist in law. None of the authorities relied upon my friend establishes that qualitative test. It would have been provided in great detail had it existed. It does not exist. And in answer to the question asked by new judge, none of the cases deal with land interposed between the person claiming riparian rights and the river. I took time in my reply to go through it because in my reply submissions to digest the facts of those cases. My friend referred to an embankment left bare through a majority of the year. That's a case of Heinsohn and Ashby. Heinsohn and Ashby deals with a fishery. Went to look up what a fishery is. It's a thing that exists in England. And in a fishery, the riverbed belongs, depending on the document establishing the fishery, and in the Heinsohn case, it was the case that the riverbed belongs to the plaintiff asserting a riparian right. There was no land owned by a separate person between the person claiming riparian rights and the riverbed. The water moved, absolutely moved in the fishery, but the riverbed belonged to the person claiming riparian rights. An estuary, I think that is the term. It's not the same. And the same case referred to by my friend, the Belizean case of brown sugar. No land in between. And the judge made the point, I found it very, very helpful, that in an estuary, the land does not belong to the persons before. It belongs to the government of Belize. So let me slow down and go through the cases as I've had them in my written submissions. The distillation of the facts are important because of the same question asked. If we turn to page 939 of the record, that's my reply submissions. I went through and digested the cases of the first respondent. the Lions and Fishmonger case, which is where the proposition comes from, the proposition that remains undisturbed. There were two noteworthy portions that I reproduced in the submissions. A riparian proprietor has no rights over the river or the shore of the river beyond the rights of the rest of the public. So that answers the question in terms of what can be given to him by virtue of having established a riparian right, which we say in the circumstances don't exist. The most material difference between the stream above and the stream below the limits of the tide are that in an estuary or arm of the sea, there exists by the common law public rights in respect of navigation and otherwise, which do not generally exist in non-tidal parts of the stream, and the fundus or bed of the non-tidal part of the stream belongs generally to the riparian proprietor, while in the estuary it belongs generally to the Crown. This property is located on an estuary, which is the river flowing into the sea. That is different from the case of Hindson, Ashby and Hindson, which my friend said there was an embankment that was left dry some of the year and overflowed during a considerable part of the year. Paragraph 24 of my submissions, I highlighted the portions of it. 25. The first noteworthy thing is that the Hindson case concerned a fishery, and the rights of an owner of a fishery as regards riparian owners depend primarily on the meaning of the doctrine under consideration and on the extent to which the owner of a several fishery is to be treated as the owner of the bed of the river within the limits of his fishery. In the Hindson case, there was no property between the river and the riparian land, as in the situation in the case at bar. So that is the factual case. The cases as well, the case of Port of London and Caney Island commissioners went through it in my reply submissions. That the ditch, seawall, embankment in the Caney Island case was built on the plaintiff's land. It was built on the land of the person asserting riparian rights. None of the cases cited by my friend, as a matter of fact, confirm this assertion that you can have riparian rights over land belonging to someone else. The fact that your land touches somebody's land that touches the river does not give you riparian rights. The description of what, sorry, if I may share with the court, the pictures referred to about the location of the fence, because I think Mr. President had asked me about it in my original presentation, if I may share with the court.
President, is she there? She fell off the call.
I'm not seeing her on the call. Okay, she's coming back in.
Apologies.
Yes.
I accidentally clicked the leave button instead of the share button. Sorry. It is taken from.
We're not seeing it, huh?
Yeah, I'm putting it up now,
Oh.
Mr. President. Are you seeing it now? This comes at page 431.
No, it's not coming up.
No, not coming up.
Yeah, yes, it is. It is.
Yes?
I'm seeing it.
For me,
I'm seeing
yeah.
it, President.
All right.
Oh,
All
okay.
right. This is page 431
Yes.
of the record. It's one of the exhibits to Mr. Matus's witness statement. That is the fence that the appellant constructed. And you see there the distance between the fence and the river. Does that help, Mr. President?
So the area on the left, that
is the first respondent's property. If I can scroll up to another one of his exhibits where my friend said he took pictures of the property. This is on page 427 of the record, AM7 to Mr. Matus's witness statement. I think this is a picture of what he describes. This is AM7. I'll take you to what it is, but please note the land, the piles, and the river in the back. I will take you to his description of this document that he had used, AM7. It's at paragraph 8. If I may read paragraph 8 into the record, this is paragraph 8 of his witness statement, Mr. Matus's witness statement. In early 2007, I discovered a parcel 5031 was created out of the entire reserve area, and this parcel was sold by the government of Belize to the third defendant. I first discovered this because I saw construction going on in the area of the reserve. No one told me that this parcel was going to be created, and I was not notified or consulted when it was being surveyed. I just simply observed that the third defendant commenced the construction of a fence to block off my entry and exit to the reserve area. The fence was substantially completed at the end of 2017, and since that time I have been prevented from having access to the reserve area, and I could no longer access the Belize River. I attach here to, as AM7, a picture showing the casting for the fence built by the third defendant with one piece of steel exposed, and in short distance there is the Belize River. The water came
You're breaking up badly, Ms. Barrow. I don't know why.
Sorry, Judge. I'm simply reading what he says in paragraph 8.
Yes,
we could read it.
So that to me makes clear what AM7 represents.
So what's the conclusion that you draw from this?
The thrust of it is that water did not come up to the first respondent's property, 4105, on a daily basis to establish sufficient contact for the establishment of riparian rights. The facts do not lend themselves. The facts, as the first respondent himself has deposed and testified, do not lend themselves to such a finding. That the requirement is, as has always been, that it must come in contact, that the water must come in contact with your land, or your land must be in contact with the water for a part of every day.
Okay. Thank you very much. Is that the conclusion of your submissions? I think she's frozen.
One more thing, Judge. First respondent's right to access that pier because it was not properly built. So if that pier was built on the government's land or what is now my client's land, we say, then the access to the pier is not what he's entitled to. If the court, and I understand the question being posed, determines that there's an easement of necessity that must come, it's not an easement to the pier, it's an easement.
Go on.
You're breaking up, Ms. Barrow. Are you hearing us?
Sorry, Judge, I was just saying that the pier that was built was not built with the permission of the owner at the time, which is the government of Belize. It was not properly built. And if an easement of necessity has to be created, which is what I understand this court to be saying is a possible outcome, it need not be at that point. It need not be there. An easement of necessity can be created anywhere to allow access, not to the pier because the pier was not properly constructed, but to allow access to the river.
And the location of that access route would be the subject of negotiations in the first instance, right?
Yes, if an order comes from the court, if an order comes from this court that an
Yes,
easement must be
on the
created,
hypothesis,
then,
yeah.
On that hypothesis, my client will be made to understand and appreciate that if that easement of necessity is something found, then it can happen at a place that is convenient to both parties.
Okay, thank you.
Yeah. Okay, I take it that's your submissions, Ms. Barrow?
Those are my submissions in reply. Thank you.
Okay, well, thank you very much. We will take time to consider our decision in this matter, and we will let you know when we are ready to hand down the judgment. I wish to thank you all for your patience and your submissions. Madam Deputy Registrar, you may close the proceedings.
Thank you, President Saunders. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Roger-Lee. Thank you, Mr. Justice Burgess. And thank you, Madam Justice Ononewu. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.
Thank you very much.
Thank you.